Good. Yes, Mr. Chaffee.
My Lords, before the short adjournment, I was about to go to quark fishing in the European Court of Human Rights. Could we do that now? It's Court Authorities, Volume 2, tab 29, page 1225.
Yes.
And the key bit that only parts I need to show you are page 1227, where the court explains why it's rejecting the application. The first point that's made, page 1227, under the heading "The Law," halfway down the first paragraph, said the courts in the United Kingdom were unanimous in finding that it did not, and although varying somewhat in their reasoning, they all found that South Georgia was a territory for which the United Kingdom was responsible within the meaning of Article 56 of the Convention, and no declaration extending Protocol Number 1 to that territory had been lodged by the United Kingdom. So it was accepted in that case, quark fishing, that the United Kingdom was responsible for the international relations of South Georgia. That premise is not accepted in this appeal, and that's the important distinction. The court then went on and made two further points under the heading first and second on page 1227. The first point is the court says that the applicants rely on the court's case law that indicates that in certain circumstances the responsibility of the contracting state was capable of being engaged outside the national territory, and they cite for that proposition a case called Bankovich in the Grand Chamber, and it's that case that was effectively overruled by Al Scaney and the United Kingdom, which we'll come to. And so the court then goes on to explain that applying Bankovich, an extension of the convention outside its regional basis is exceptional, and therefore the claim is rejected. And the second point, which is made at the bottom of page 1227, is the applicants argued that the Article 56 system was outdated and geared to the colonial systems in the aftermath of the Second World War. And over the page of 1228, the court agrees that the situation has changed considerably, but that only goes so far. It doesn't allow the court to rewrite the convention. And then about 8 lines down on page 1228, the court says again, since there's no dispute as to the status of South Georgia as a territory for whose international relations the United Kingdom is responsible, within the meaning of Article 56, the court finds the Convention protocols cannot apply unless expressly extended by declaration. So it is notable that the court says twice that it is that premise, which is the premise on which the application is being rejected, that the UK is indeed responsible for the international relations of that territory.
But Mr. Jaffe, is there any analysis anywhere of the meaning of the word responsible? I recollect from Al Scaney that it was referred to there as something of a bit of a historical anachronism, even when the convention was drafted, and it seems to be referred to here as an incident of formal colonialism. Your case is that it assumes legal and lawful responsibility as opposed to unlawful responsibility. Is there anything in the Travaux preparatoire which supports that or provides guidance on that we have?
No, there's not. It's not that we're aware of or been able to find. It's undoubtedly the case that the purpose of Article 56, that originally was Article 63 of the Convention, was to deal with that situation of colonial overseas territories which either might or might not have the Convention extended to them. And there were numerous different types of situation in which that might apply. So let's take, for example, an overseas territory, and we give the example of Gibraltar in our skeleton argument, which is a self-governing and democratic overseas territory with its own legislature, executive, police force, and so on. Now, in those circumstances, our submission is that in the absence of an Article 56 notification, there would be no prospect of the Convention applying, because the United Kingdom is not in effective control of the territory in any sense. And so if someone was, for example, beaten up by a police officer or unlawfully detained by the Gibraltar police, in the absence of an Article 56 declaration, there would be no basis on which to apply the Convention. On the other hand, in a different kind of overseas territory, such as the overseas territory that we have in Mayotte, where the territory is under the direct control of the Foreign and Commonwealth Office by a commissioner who has legislative and executive powers, the position is, in our submission, different. But no, we don't think that in the Chagos or in any other materials, the parties haven't been able to find any detailed analysis at this point. The relationship between Article 1 and Article 56 is not explained in the Convention itself and hasn't been the subject of a great deal of attention. And that's a point which the Strasbourg Court made in the Chagos Islands case when declining to decide this very point. And we'll come to that next in a moment. So that's quark fishing. Quark fishing was then applied by the House of Lords in Banku number 2. Banku number 2 is in the first core bundle of authorities at tab 16. Page 410, page 410. Point very briefly on page 446 in paragraph 64 and 65 of his judgment, with whom the other members of the committee all agree on this point. If I could just invite the court to read 64 and 65. The same reasoning based on the quark fishing analysis that a declaration could have been made, but it hasn't been made.
Yes.
So the question then is whether that remains good law and binding on this court. As my Lord Justice Green just mentioned, the next stop is Al-Skani. And Al-Skani in the Grand Chamber is in the Core Authorities Volume 2 at tab 30 and page 1229 in the Core Authorities.
Sorry, could I just have the page number again?
I'm sorry, my lord, it's tab 30, page 1229.
Thank you.
In this case, essentially reversing the view of the House of Lords, the European Court of Human Rights applied the convention to parts of Iraq where the United Kingdom was acting as the occupying power, in effect as the government. The government's arguments, which are significant because they rely on Article 56, are set out at page 1279 and onwards, paragraph 111. So picking it up at the bottom of page 1279, the government submitted that the court's case law in Article 56 further indicated a state would not be held to exercise Article 1 jurisdiction over an overseas territory merely by virtue of exercising effective control there. Quark fishing is cited. If the effective control of territory exception were not to apply outside the territory of the contracting state, would agree to the jurisdiction of the state is free to choose whether or not to extend the Convention's protocols to a non-metropolitan territory outside the Convention espace juridique, over which it might find to have been found to have exercised control for decades, but was not free to choose whether to extend the Convention's territories outside that space, over which it exercised effective control as a result of military action only temporarily, for example, only until peace and security could be restored. So, in a sense, the UK is running the opposite argument to the argument that I'm putting before your lordships, which is the UK is saying, well, we're free to choose whether to apply the Convention to our overseas territories. So why can't we also, so how come we're not free to choose under Article 1 just because we are in effective control of territory in Iraq? And what's the logic behind that? So that's the argument put forward by the UK. And the court's response is at paragraph 138. Begins at 138. And if I could invite the court to read 138 to 140, with particular emphasis on 140, where the court deals with the Article 56 point. So if I can
Yes.
So if I can summarise, the first thing the court is saying in paragraphs 138 and 139 is the decisive test under Article 1 is whether there is effective control of an area. And then paragraph 140 rejects the United Kingdom's argument that Article 56 undermines that analysis. The existence of the Article 56 mechanism didn't prevent reliance on Article 1 as a separate and independent means of establishing jurisdiction.
Mr. Jaffe, can I just ask whether you say Al-Skani is limited to military action? Because both in the earlier authority that you've referred us to, Loiseau, and then this, were military cases, and Al-Skani certainly picks up at 138 lawful or unlawful military action as being the basis on which effective control is operated.
Yes. I suppose it doesn't have to be military action. There are cases in which jurisdiction has been established on the basis of non-military, but nonetheless forceful practical control. So it wouldn't matter whether it was a diplomat, for example, holding someone in an embassy, or a police officer, or other exercises of effective control, for example, running a prison. And perhaps I can give you a list of examples later on where it has been extended beyond military action. But I don't think it's controversial that the case law has in fact extended beyond that, although I agree that the examples I've given you are military cases.
I think paragraphs 131 to 137 deal with the civilian non-military application of Article 1, and 138 deals with unlawful or lawful military occupation. So the court's analysis distinguishes between the two from 131 onwards.
Yes, that's right. The court goes through its case law and explains that at 134 diplomatic and consular agents, they will have, the jurisdiction will be exercised where they exert authority and control over others. And then 135, by consent, invitation or acquiescence of the government exercising public powers normally to be exercised by the government and the executive or judicial functions on the territory of the next state. And 136 deals with the use of force, and then there are military cases which then are described later on. But nonetheless, the flavour of all of those exemptions are whether by consent or otherwise, the powers of control over individual or the government of the territory is being exercised in effect by the United Kingdom. And our submission is that clearly that test is satisfied in respect to the British Indian Ocean Territory. It is not a territory in which there is any meaningful element of self-government. The territory is governed in the interests of the United Kingdom by the Foreign Office. And I don't mean that pejoratively, simply as a statement of the practical reality. Al-Scaly was then picked up in the Chagos Islands case, which is the next tab 31, starting on page 1311. This is Banku number 2 in Strasbourg, and it's an admissibility decision taken by the full section, apparently by majority, though we're not told what the majority is, because the practice is not to produce dissenting judgments on admissibility applications. And this issue was then considered by the section, paragraph 75 and 76 of the judgment. Paragraph 75 and 76 are on page 1325. If I could invite the court to read 75 and 76, where the court leaves this point open.
Presumably you rely upon the word there in the last line of paragraph 75, their overseas territories.
Yes. Now, the court finds it unnecessary to rule because the applicants lost on other issues, in particular victim status, which I'm about to come to. But at paragraph 75, the only concern which is expressed is that Article 56 would be rendered purposeless and devoid of content, since contracting states did and do exercise authority and control over their overseas territories. Well, you already have my response to that point. It very much depends on the overseas territories, and any overseas territory which exercises any form of self-government is unlikely to satisfy the Article 1 test. Gibraltar. So the appellant's position is that Article 1 and Article 56 work perfectly well together, and in particular recognising jurisdiction under Article 1 based on practical control doesn't render Article 56 a dead letter. What it does do, of course, is it avoids the very strange outcome that the British Indian Ocean Territory would be one of the few places in the world in which the United Kingdom can commit breaches of the Convention whilst it's in control of territory. So, for example, the logic of the Divisional Court's analysis is that the British Indian Ocean Territory is a place in which UK officials could, for example, carry out an extraordinary rendition operation or torture someone without breaching the Convention. and it would be one of the only places in the world, because it's an overseas territory, in which that could occur. Now,
Sorry, Mr. Jaffe, a moment. I'd like to know, you put forward paragraph 140 of Al-Scaly as a clear authority on which you rely, that the fact that in the present case Article 56 has not been operated to extend the application of the Convention to the Chagos Islands doesn't prevent the application of the Convention through Article 1. You rely on that as direct authority.
I do rely on paragraph 140.
Right, as a
I
direct
don't say
authority.
it's absolutely clear and determinative, because of course in a later case, the Chagos Islands case,
But that's what I'm coming to. So I'm trying to see the reconciliation. I thought before we got to Chagos Islands, you were saying that about 140, about in relation to this case. But what is clear is, as you rightly say now, it cannot be determinative. It cannot apply, despite what it says on the face of it in 140, specifically to the Chagos Islands, because of 75 in the Chagos Islands case. So it's plainly not clear authority. Now, what I'm asking you really now is, well, how are you reconciling your submission on 140, on which you rely, with the plain reservation of the court in 75, saying, well, we don't, I mean, they're obviously saying we don't accept it, that's what it says, and we want to reserve our view about that point.
yes, that's right. The way I put it is that paragraph 76 of the Chagos Islands case say the court finds it unnecessary to rule because the claim fails for other reasons. And then in 75, as my lord rightly puts to me, the court expressed reservations. And the reservation that the court expressed was, wouldn't Article 56 be left as a dead letter? Wouldn't it be rendered otiose? Because in pretty much every case, there would be jurisdiction under Article 1, thus depriving the state of the choice of whether to extend the convention. And my response to that is, if that is the only point that's being raised, the answer is that Article 56 is not a dead matter, because it would retain decisive importance in the case of any overseas territory which, as most do these days, exercise self-determination and run their own affairs, particularly in relation to breaches of the convention. There aren't many overseas territories these days which do not have their own police force and their own governments and their own laws. And if they exercise that type of freedom and their own control, Article 1 has no application.
Well, I know, but weren't they considering, so if I can just press this point, but they were considering this issue, not generally, but in the context of the Chagos Islands, and in the context of Bancourt Number 2, where the whole, as it were, the whole essence of it was that the original exclusion of the Chagosians was a wrongful act. I mean, the facts were there. It may be that in other cases there might be some issue, but why was the court so reluctant on the facts of this case not to say, why were they reluctant to say that Article 1 applies in any event?
Well, I can only speculate, but I suspect there was considerable disagreement in the court in the Chagos Islands case, and the majority in favour of dismissing the application was obtained on the other grounds, and the court declined to decide the issue precisely because there was disagreement.
But
that is pure speculation, but all I can say is that they haven't decided this and they've left it open.
But I think it goes a bit further. They've not only not decided it, but they've decided, have they not, that 140 of Al-Scaly is not to be read as providing that irrespective of Article 56, you can still, as it were, get home with the Convention under Article 1 in all cases.
I don't think they've decided that against me. I think they've left that open, my lord.
Right, they may not have decided the point against. No, they may not have decided the point against you. All I'm saying is, what they have decided is that 140 can't be read as one might have read it otherwise, in accordance with its terms. There's a qualification there. I left unclear what the qualification is, but there's a qualification to 140. Well, as if to say, well, yes, they applied 140 in Alscaney, but we've got to be careful about its wider application outside the facts of that case.
Well, the court has said that it's leaving it open. I can't put it any further than that.
No.
That's all the court is doing. The court is accepting that the argument exists. So at the beginning of 75, the question remains as to whether the passage from Alscaney indicates there must now be alternative bases of jurisdiction. The concern is about rendering Article 56 pointless. I sought to answer that. But even accepting 76, the above interpretation, the court finds it unnecessary to rule. So that's where it is in terms of the Strasbourg case law. It's expressly left open.
Yes.
But I say in this case, it's open to the court to decide that the submission is correct in relation to Article 1 and Article 56 being alternatives, not least because the premise on which all these cases proceeded, namely that the United Kingdom was properly responsible for the international relations of British Indian Ocean Territory, has, as a result of the advisory opinion and the General Council resolution, in our submission, fallen away.
But can I just now, I do understand the submission, thank you. But how do we fit into that? I think the general advice that's usually followed, Lord Bingham's warning, that the English courts should keep pace with Strasbourg but go no further.
Yes. The other principle is, of course, an important principle, but what it means is that it doesn't prevent the domestic courts from applying a clear and established line of Strasbourg case law to a new factual circumstance or a new situation. The court doesn't have to await the decision of Strasbourg when the principles to be applied are ones that have already been identified, particularly in Grand Chamber decisions. And I suggest the relevant principles are ones that are tolerably clear as a result of Alscaney. And just because the Strasbourg court has left a point open for decision in a future case doesn't mean that the court can't tread there in this case.
Thank you.
The final step in the argument is about the subsequent reception of Alscaney in the United Kingdom and the analysis now.
Just before we move on to that, can you just consider the facts of Alscaney just a little bit? That was a case which concerned not an overseas territory for which we had responsibility, it was Iraq.
Yes.
The acts complained of were committed before the interim government was set up, but it was in an area of Iraq over which we were deemed to have security control by virtue of our agreement with the US. So it wasn't a state over which we had responsibility, if that is a defining feature of Article 56. So Article 56, as I understood it, couldn't apply to Iraq, and therefore the court was analysing whether de facto effective control was sufficient to trigger Article 1. Now, is the fact that we had some degree of control sufficient to make Iraq comparable to the Chagos Islands, where we had what we purported to exercise as legal control? How comparable are the two situations on the facts?
Well, the position in Iraq was that the United Kingdom was in occupation. It was an international armed conflict in which the United Kingdom and its allies took physical control following an invasion of Iraq. And the United Kingdom and its allies became occupying powers for the purposes of international law and had an obligation, under international law, to conduct the government of Iraq for that period. And that was sufficient, held the Grand Chamber in Alscaney, for certain obligations, not necessarily all of them, but certain obligations under the Convention to follow under Article 1 because of the control being exercised. Here, the nature of the control being exercised as a matter of international law is unlawful administration of what purports to be an overseas territory. And the question is therefore, apart from Article 56, is there any practical difference? And in our submission there isn't. And the reason for that is that the United Kingdom is exercising the administration of the territory de facto. In Iraq, it happened to be lawful. It's a matter of international law. It was a lawful occupation. In relation to the British Indian Ocean Territory, it's the unlawful administration of the territory. But whether it's lawful or unlawful, the key thing in the Strasbourg jurisprudence is the practical control. And the question which remains, therefore, is the question which my Lord Master of the Rolls has put to me, which is, well, does Article 56 make the decisive difference? And by reference to the arguments that were put by the UK the other way around, where they said, well, you can't make us responsible under Article 1 because under Article 56 we have a choice, and so surely you can't go wider than that. Well, I turn the argument around from its rejection and say, well, again, Article 56 is not the exclusive means. Now, there isn't any Strasbourg authority expressly finding that in the claimant's favour, but in light of the advisory opinion and the clear line of analysis which I sought to identify to the court, that is in my submission the right analysis. It's an Article 1 case. Now, if I'm wrong about that, and first of all, if I'm completely wrong about the analysis, then of course the appellants lose. If the analysis is at least potentially right, but the court considers nonetheless it's still bound by Banku number 2 and Quark fishing, then the court, of course, will dismiss the appeal with the consequences that we've already discussed. And that's how it plays out. Just to finish this point, can I just ask the court to briefly look at Smith, which is the reception of Al-Sqaini in the Supreme Court. Smith is in the Supplemental Authorities Bundle, Volume 1, Tab 20, and it's at page 847. My Lords, is one of the cases which followed Al-Sqaini, which reached the Supreme Court, and it's a case of a British serviceman who died in operations in Iraq, and he claimed that he was given inadequate equipment by the Ministry of Defence, or his family claimed that, and there was a convention claim as a result. The court analyses and decides whether it's going to accept the Al-Sqaini line of authority. Can I pick it up from page 909? Paragraph 45 of Lord Hoareau's judgment. I should add that all members of the court agreed with Lord Hoareau on this jurisdiction issue. There were differences of opinion on other issues, but everyone expressly agreed on this. So paragraph 45, Al-Sqaini is summarised, and there are the court concludes that the majority in Catherine Smith, which was an earlier pre-Al-Sqaini case, if the state's armed forces abroad aren't within jurisdiction, can't be maintained. The first point is that exceptional is not a particularly high threshold. So that's the point, 2/3 of the way through paragraph 46. The second point is made at paragraph 47, which is that inconsistency between previous cases and Bankovich can be satisfied by looking at only at authority and control, and is still essentially territorial. And then over the page at page 910, between B and C, it said it's Bankovich that can no longer be regarded as authoritative on this point. And state authority and control is the principle. And Lord Hoareau's final sentence is it anchors that case, which is ISA, which is state authority and control, firmly in the mainstream of the Strasbourg Court's jurisprudence on this topic. And then the third issue is the so-called divide and tailor issue, which is whether all of the convention rights have to be delivered by the United Kingdom, even if that would be practically impossible. And the answer is no, not all of the convention rights have to be delivered. Because it may be that due to the physical circumstances in Iraq, it would be impossible for the UK to be responsible for delivering compliance with all the convention lines. Then paragraph 52, Lord Hope cites the Cypriot cases, including Lloyd's and Turkey. And then, having cited them between F and G, says, as matters now stand, given that guidance has now been given in Al-Skani, it deserves more attention, and that's the Cypriot cases. The logic which lies behind it, as explained by Lord Mance, is compelling, and then applies it to the armed forces and the chain of command under which authority is exercised from headquarters down to divisions of armed forces operating abroad. It explains how that brings into the scope of the state's authority and control. So that's, in our submission, a straightforward acceptance that the Al-Skani line of authority is the right line of authority, which can be accepted and applied domestically. That cases which have applied the pre-Al-Skani Bankovich line of authority are no longer to be regarded as good law, and that the court should read and apply Al-Skani as the guide to Article 1 jurisdiction. Now, it doesn't expressly say Bancourt number 2 doubted, overruled, or whatever, but in my submission that's not necessary. The reasoning in our submission has to be reconsidered in light of that analysis. Can I turn now and deal with the issue of victim status, which is the second basis on which the Divisional Court rejected the human rights claim? The court's reasoning, the Divisional Court's reasoning on victim status is paragraph 155 of the decision below. That's in the core volume, tab 21, page 220. So the court's reasoning starts at 145. Claimants cannot properly be described as victims for the purposes of Article 34 of the Convention and Section 7 of the Human Rights Act. In this context, we note that the right of individual petition has never been extended to the British Indian Ocean Territory under Article 54 of the Convention, but there are more fundamental problems. So, dealing with the initial objection, that's not an accurate point. The basis of jurisdiction relied on is Article 1 of the Convention, which is based on the United Kingdom's jurisdiction, not an extension under Article 56. There was no need to extend to the British Indian Ocean Territory the right of individual petition, any more than there was a need to extend the right of individual petition to a British base in Afghanistan. There is, I don't think, any real support by the Secretary of State for that line of analysis in their skeleton arguments. I'll be corrected if I'm wrong in due course. Then the more fundamental objection of the court below is at paragraph 146 and 147. And they cite and apply the analysis of the Strasbourg Court in the Chagos Islands case. And so the first quotation of 146 finishes with the comment that whatever the outcome of these proceedings, the applicants continue to have no legal or practical prospect of being able to enter or settle on the islands. Well, does it remain the position that there is no legal or practical prospect of the appellants being able to enter or settle on the islands? Well, we now know from the International Court of Justice's advisory opinion that the UK administration is a serious breach of international law. It's continuing, and the UK is under an obligation to bring to an end its administration as rapidly as possible. And we also know that the proposal of the International Court of Justice is resettlement, including resettlement of Chagos Islands. And that's followed up by the General Assembly resolution. So it can no longer be the case that there is no legal or practical prospect of Chagosians being able to have a right to enter the territory in these circumstances. And the second point the court relied on, paragraph 147, the court quoted paragraph 83 of the Chagos Islands decision. The basic point made in paragraph 83, from halfway down the quote, is the claims were raised in the domestic courts and settled definitively. The applicant's attempts to pursue matters further in more recent years must be regarded as part of an overall campaign to bring pressure to bear on government policy, rather than disclosing any new situation giving rise to fresh claims under the Convention. That's a very different flavour from the International Court of Justice, which said that the resettlement of Chagosians is an issue relating to the protection of the human rights of those concerned. That's paragraph 181 of the advisory opinion. And so the suggestion in this admissibility decision that this is purely a historical rather than ongoing issue and doesn't engage questions of fundamental rights is, we suggest, incorrect. And so, in light of the advisory opinion and its acceptance by the General Assembly, our submission is this majority admissibility decision isn't any longer the answer to the question of victim status. And for the reasons I'll go on to identify, the appellants are plainly victims because they've suffered a serious interference with their ongoing rights. So that's victim status models. The next step in the Convention analysis is interference. And the Divisional Court dealt with this in paragraph 148 of its judgment. They say any Convention rights which may have existed no longer exist. The present case is not concerned with what happened in the 60s or 70s, it's concerned with decisions in 2016. They did not constitute interference with any of the rights in the Convention. For example, the right to peaceful enjoyment of possessions or the right to respect for the home. Now, that conclusion is in some ways a surprising one, even before looking at the Strasbourg authorities on interference. Because let's assume that, for example, the government encouraged and facilitated Chagosians to return to their homes every week or every year for a week or two. Let's assume that that meant that the islands and the church and the family graves and so on were well tended. And let's assume that the islanders lived and visited quite extensively, on and off, over the course of the years. On the logic of the Divisional Court, simply by virtue of keeping the islanders away, forcibly and by operation of law, the government has succeeded in removing any interference with their rights. The proper analysis, we'll suggest under the Strasbourg case law, is that in fact, such conduct makes the breach of the rights more serious, rather than eliminating any interference. The proper analysis is that rights can be lost under the Convention where you haven't been able to exercise them for a very long period, but not where the deprivation and the refusal of permission to exercise the rights arises from wrongdoing. Where a person's been denied their ability to exercise rights, they're not lost as a result. In order to make that good, can I just show the court a couple of decisions, most of which were cited below, but which weren't dealt with in the Divisional Court's reasons. All of the decisions point back to an unusually important chamber decision called Dogan and Turkey, which is in the Court Authorities of Volume 2, tab 28, page 1191. Then we could invite the court to turn that up. For reasons the court will know, I try to keep off chamber decisions wherever possible because they have limited persuasive and authority value. But this decision has been repeatedly approved by the Grand Chamber as we'll see in a moment, and therefore it's potentially quite important.
So this is the core bundle of authorities, 2, second volume.
Core volume 2, tab 28, page 1191.
Thank you.
And this is a case in which the Turkish security forces removed the inhabitants of a village in a Kurdish area and kept the villagers out of their homes and out of the whole village for a decade. During that decade, the properties fell down and were rendered entirely uninhabitable. And the court sees that at paragraph 38 of the judgment, which is on page 1201. The houses have basically substantially collapsed. And what the Turkish government argued is, first of all, that the applicants had no actual property rights in respect of their homes. And secondly, there was no interference because the properties didn't exist and they couldn't in practice go back. So it's the same points as were adopted by the Divisional Court. And you see those arguments recited and recorded by the court, paragraphs 136, first of all, where the Turkish government says that you have to have title to the property. And then 141, that the properties didn't exist anymore, and so there was no right to a home which is relevant. Now, both those arguments were rejected by the court, and the court's conclusions are at paragraphs 138 and 139. And if I could just invite the court to read those two paragraphs.
Yes.
So the points that are made are you don't need to show any domestic law title, still there's a title to real property, economic rights over a commons, earning a living from the land, the waters and practical economic resources, and informal homes which are built and erected are sufficient to engage rights under the convention. And then paragraph 143 on page 1217. It's a lengthy passage, but towards the end of that passage, the court points out that the deprivation had been for 9 years and 10 months, but that didn't prevent an interference having been found, so despite a long absence. Now, the reason, as I've said, I show you this case is because it's been subsequently approved and applied by the Grand Chamber twice in cases arising out of the conflict between Armenia and Azerbaijan over the Nagorno-Karabakh area. Those cases involved exceptionally long absences of, between the person being thrown out in the court's decision of, I think, 24 to 26 years. And the court will see that, first of all, at tab 32 is the judgment in Chagos and Armenia, at page 1329. And the bit where the court deals with Dogan starts at paragraph 131 on page 1378. cites Dogan at paragraph 131, and then at 136 on page 1380, the court emphasises its flexible approach to rights to property and their interference, and then it's applied to the facts at paragraph 146 and 147. The issue in that case was that there was a Soviet system of property ownership under which all land belonged to the state, which is a bit like British Indian Ocean Territory, where all land is crown land. But there were de facto rights to erect houses in these land, which were recognised by the convention as capable of being interfered with. And in this case, the court also applied the Loisittu line of authority to find jurisdiction. And the second case, which also applies Dogan and gives more detail about it, is at tab 33, the next tab, page 1467, called Sargistan and Azerbaijan. The approval of Dogan is at paragraph 234 on page 1531. And if I can invite the court to read paragraph 234, but in a sense reflect some of the points which my Lord Justice Green made to me earlier, that when there are interferences with rights, there may be a fair balance that can be achieved by providing an alternative, other forms of assistance or compensation. But nonetheless, what needs to be done depends on the circumstances, and these rights can be interfered with even if they're not formal rights. The shape of the arguments that was put before the court were essentially the same arguments as in this case. So what the applicant said, and this is paragraph 245, is that page 1533, even though he'd been kept out of his property for a very long time, and this is the fifth or sixth line, these links were not broken by prolonged involuntary absence. So that's the applicant's submission. The government of Azerbaijan's response is paragraph 248, the top of page 1534. No longer a persisting link with the property concerned. The house had been destroyed during hostilities as long ago as 1992 and could no longer claim to have a persisting link with a home in Gulistan. And then the court's conclusion on those competing arguments is at page 35, paragraph 257. Accepts that the applicant had a home in inverted commas, which he left involuntarily in 92. The gist of his complaint is he's been unable to return ever since. In these circumstances, his prolonged absence cannot be considered to break a continuous link with his home. He lived in Gulistan for the major part of his life, must have developed most of his social ties. Inability affects private life, and in the circumstances of the case, his cultural and religious attachment with relatives' graves in Gulistan may also fall within the notion of private and family life. And so the inability to return affects his private and family life and home. Now, again, that conclusion of the Grand Chamber, talking about informal rights, the opportunity, for example, to visit and attend family graves, and even in respect to the home that's been destroyed in conflict, amounting to an interference, is entirely inconsistent with the analysis of the Divisional Court. And the Divisional Court's analysis is incorrect in light of it. Now, it may well be that long absence is a factor which can be taken into account when deciding whether a fair balance has been struck, but whether there is an interference is, in the appellant's submission, clear there has been. So the final step in the convention argument is breach, which I've already made submissions on and I won't repeat. It wasn't dealt with by the Divisional Court, and that's because the Secretary of State also made no submissions on the point. There has been no analysis to suggest that a fair balance has been struck, either under Article 8 or under Article 1 of the First Protocol, and so the proper course is to require the decision to be reconsidered in light of the convention obligations. And of course I accept, as I must, there may be a range of lawful decisions which could be taken applying the convention.
Mr. Jaffe, can I just ask, going back to step 2 on your argument, which was victim status, because I don't think you've addressed paragraphs 81 to 83 of the Chagos Island case, which I think is page 1326 of the core bundle, and the reliance that the European Court of Human Rights put on the settlements. Of course, you're right to point out other cases where there have been delays, but there haven't been other cases where there have been settlements.
Yes, well, the question there is that the court, the European Court of Human Rights in the Chagos Islands case, found that there was no possibility, either legal or practical, is the words that they used, including no possibility of settlement. So on the legal side, you already have my submissions about the International Court of Justice and the correct position. On the practical side, the International Court of Justice is again absolutely clear, because the position is, as it must be, that the ongoing administration of the United Kingdom has to come to an end, and hopefully has to come to an end soon. The clear and stated position of the Mauritian government is it wishes to resettle the islands, including resettlement of Chagos Islands. And so if the question is who pays for it, of course the United Kingdom, we know, doesn't want or intend to pay for it at all. But on the question of whether there is a practical prospect of resettlement, the answer to that, in light of the advisory opinion, must be that there is.
One expression is slightly different, and it's concerned with commercial settlement of the litigation rather than resettlement. That's what paragraph 81 of Chagos, I think, was concerned with. Does the fact there's been a settlement as a litigation? I don't know.
There has been a commercial settlement of litigation involving Mauritian Chagosians. There has not been any, for example, involving white lines, and that's why, for example, the effect of this decision bears particularly heavily on Seychelles Chagosians. But there has also been no settlement of any litigation in respect of the decision which is currently under challenge, the decision in 2016. There's been no suggestion, for example, that the parties are barred by a settlement agreement in contract which they have agreed to, which prevents this litigation from being brought. That would be a fundamental threshold challenge which could have been raised in the Divisional Court and hasn't been suggested that this claim is not one that the court can properly hear because there has been a settlement. Because the government has decided in 2016 to reconsider the whole question of resettlement, including the right of abode, and to take a new decision in the current circumstances. And so, therefore, in those circumstances, that decision is open to challenge, including under the Convention. So, I'm not criticising the decision of the Strasbourg Court in the Chagos Islands case on this point, because I don't need to, but because the situation has very much changed, because there is a new decision. And it's not suggested it's barred by any settlement parties have entered into.
The Divisional Court seemed to think that the fact there was a commercial settlement of the litigation is relevant to the definition of victimhood. Is that correct? Are they connected? I mean, if you settle something, it might, I suppose, arguably presuppose that you were a victim, you had a claim which was settled. It doesn't necessarily, I suppose.
Not necessarily. I mean, I think that's potentially quite a difficult dividing line. If for example, I own a car, and there's a dispute about who really owns the car, and I come to a commercial settlement as to who owns the car with the other party who claims they own the car, then that probably marks the end of my Article 1 of the First Protocol rights in respect of who owns the car, and the Strasbourg Court will look only at the domestic law contractual position. When it comes to a decision which is taken in public law about, for example, the right of abode, the approach may be somewhat different. But certainly, at the risk of repeating myself, there hasn't been a suggestion that there's been any settlement of the decision which was taken in 2016, or that a challenge to that is barred by a settlement agreement.
In relation to your clients?
Certainly in relation to my clients. I mean, if there are other settlement agreements that aren't public, I haven't seen. But I don't believe there are, which would prevent a challenge, such as the challenge that's been brought. If there was some actual bar, then I assume we would have heard about it from the Secretary of State by now. Maybe there is, I don't know. But certainly in respect to my clients. That leaves the support package issue, which I can deal with quite briefly before completing my submissions. Just going to tidy up, if I may, for a moment. Just one further point in response to my Lord Lord Justice Green's question about settlement. The position in relation to my clients and what has been agreed or not agreed is set out in our skeleton at paragraph 57, which is on page 75 of the core bundle. And it just sets out in a bit more detail with the references to the point I've made that there's certainly been no settlement in relation to anything which binds or affects the Seychelles Chagos Islands. That leaves the support package issue, which is a ground of appeal that's pursued by Mr. Hoareau only. Can I start, if I may, with the written ministerial statement, which explains what ministers, when announcing it, thought the support package would achieve. The decision in relation to the support package is in the core bundle, tab 15, page 169. It's the penultimate paragraph on page 169. The government will seek to support improvements to the livelihoods of Chagosians in the communities, plural, where they now live. I can now announce we've agreed to fund a package of approximately 40 million over 10 years to achieve this goal, addresses the most pressing needs of the community by improving access to health, social care and improved education and employment opportunities. This fund will support a significantly expanded programme of visits to the territory for native Chagosians and will work closely with Chagosian communities in the UK and overseas to develop cost-effective programmes and so on. So that's what the decision was intended to achieve. Now, what the Divisional Court said about this argument, the Divisional Court explained exactly what was an issue. In its judgment, starts at paragraph 300, and that's page 252 of the core bundle. Where the court deals with this under the heading of issue 6, or package challenge. And if I can pick up the court's judgment at paragraph 306 on page 253, there's an explanation, and the court sets out its findings of fact as to how this figure of 40 million was arrived at. So, further work on cost assessment was carried out for health and education, and the Department for International Development officials produced a working draft proposal showing a total figure of 20.5 million for Mauritius and 6.6 million for the Seychelles. The overall overseas development assistance eligible component in the Department for International Development package was shown at 27.1 million, and a separate package was prepared AFCO's budget at a cost of 19 million. So you add together 27 million and 19 million, and you get to 46 million rather than 40. So at some point, that figure was reduced to 40 million. And what happened was the assessment of the costs of delivering that package in the Seychelles was removed from the calculation. And that's what led to the reduction from a total of 46 million to 40 million. And that isn't in dispute, as I understand it, and there's an explanation as to why that happened at paragraph 307 over the page. DFID officials realised that the Seychelles might not be eligible for overseas development assistance beyond 2017 because of their overall national wealth and GDP. An email from Dr. Dick stated that at a Cabinet Office meeting the week before, DFID had been allowed to reduce its budget to 21 million accordingly. And that's how the figure was ultimately set. DFID basically decided that the Seychelles as a nation might be too rich to come into its criteria for overseas development assistance, and so therefore they weren't prepared to fund it. And so therefore the element of the costings which related to the Seychelles was removed from the costings that were put to ministers. And that's how we ended up with 40 million. You can actually see that even more clearly in the documents that were disclosed before the Divisional Court. I'll only show the court one of them, if I may. It's in the supplemental bundle for the hearing. At page 541.
Sorry, which of our bundles is it in?
The supplemental appeal bundle. We haven't got to it yet. I suspect it will prove to be a very supplemental bundle overall. It's going to be used more in relation to the right of the vote issue rather than the issues that I'm addressing. But first supplemental bundle, tab 56, page 541. Hopefully the court has a table which explains this breakdown that's summarised in the Divisional Court's judgment.
What's the date of the table? Sorry, it doesn't appear to be dated in my copy.
Yes, it's attached to an email which starts at page 538, and it's the 28th of April 2016.
Thank you.
So looking at the table, the top half of the page is the costings for Mauritius, and the bottom half is the costings for the Seychelles. Your Lordships will see the proposals of what would be funded over the 10-year period. So the construction of a healthcare facility and additional tuition classes for certain numbers of children in primary and secondary education, funding the cost of further education. And then the same costs on a smaller scale in the Seychelles, reflecting the smaller Chagos Islands population there. Then the costings are on the right-hand side of the page, and the two critical numbers are that it would be thought to cost 20.5 million to achieve all of that in respect of Mauritius, and 6.6 million for the Seychelles, giving a total of just over 27 million. And as the court can see, the particular numbers of people who would be supported, children, further education, adults, and so on, and the number of patients who could be treated are set out in the table. So what happened is DFID said, well, it's not coming out of our budget, anything in relation to the Seychelles. So a line was put through DFID's contribution. They said, well, we'll pay for the Mauritius stuff, but not for the Seychelles. The Foreign Office wasn't prepared to offer any more money, and so the figure that was offered, or that was decided upon, was approximately 40 million, rather than approximately 46 million. Now, it could well be that that would be perfectly proper, because the government might decide that, well, we just simply can't afford it. We're not prepared for it to come out of any budget other than DFID's budget, and for sound reasons we're not prepared to pay more, and so that's the end of that. The problem with what happened is that this package was then presented to ministers on an incorrect basis. The Prime Minister was personally briefed that a budget of £40 million would provide these benefits in both Mauritius and the Seychelles, even though in fact officials knew that they would not. And that can be seen in the memo that was provided by the National Security Advisor to the Prime Minister on this issue. That memo is in the second supplemental bundle at page 599. Which is tab 70. A memo to the Prime Minister from Sir Mark Lyle Grant, who at the time was the National Security Advisor on these issues in the British Indian Ocean Territory. And the development package, now called the support package, is dealt with at page 602, paragraph 8. And the National Security Advisor says that the proposed joint FCO DFID package, which is based on their best assessment of Chagosians' needs, would include, so this is what you're going to be agreeing to fund, Prime Minister, improved access to healthcare, education and employment for Chagosians on Mauritius and the Seychelles, providing new primary healthcare facilities, 2,000 private tuition places, 500 vocational training places, and so on. And those numbers are obtained by adding up the figures for Mauritius and the figures for Seychelles, the table we've just looked at. Heritage visits, and then see a training package in relation to literacy, numeracy and environmental issues for Chagosians in the UK. And then it said the activities in A would be funded by DFID and would be ODA eligible. The rest would be funded by a combination of FCO and a particular fund and would be non-ODA. This is more a figure that was originally mooted, but it's based on a better understanding of the likely costs and demands. The Prime Minister then approved the package on that basis, and that's page 606, tab 72. And one sees an email from Mr. Perry, who I think was the private secretary to the Prime Minister at the time, and in the middle of that page, the Prime Minister has also decided we should announce the rollover after the UN General Assembly alongside a development package for Chagosians in Mauritius, the Seychelles and the UK worth around 40 million over 10 years. So that's the decision. So what the Prime Minister was told is that with 40 million you can provide this package, which will cover these needs of Chagosians both in Mauritius and the Seychelles. But of course you can't, because the costings show that 40 million will not include the cost of doing any of these things in the Seychelles. That will mean that you can't do at least some of what ministers were told was possible on the figure they were invited to agree. And that's the problem with this decision, that it proceeded on the basis of a fundamental mistake of facts in judicial review terms. Now, the Divisional Court rejected that argument, and the submission which I made is recorded by the Divisional Court in its judgment, paragraph 311.
Sorry, Mr. Jaffe, just before we go to the Divisional Court, can you just help me with page 588, which was one of the documents I read over the weekend?
Yes.
Because this is the same, I think it's a couple of days beforehand, but it's also about money. And the recommendation was 2-1 to agree a figure of 40 million etc., this figure is less than the combined total of outlined previous costings. If you look at the end of 2.1.
Yes, that's right. And that's because the original figure that was proposed was 55 million, much higher, and that was proposed without the detailed work, including the table that I've shown the court, having been prepared. And that's the point which is made in Sir Mark Lyall-Grant's submission to the Prime Minister about a previous proposal of 55 million, but now the current proposals are much more defensible and modest. But that is a separate issue from what's happened here, which is, I'm not making any objection to the fact there was a reduction from an initial internal proposal of 55 million down to 46. What I suggest is unjustified, and where the mistake was made, the public law mistake, as opposed to a judgment of government about what the budget ought to be, is in the reduction from 46 to 40, because it was presented on an incorrect basis. So my lord is quite right to raise that with me. And just if I can, to make that point good, going back to the brief to the Prime Minister, one sees that at page 602. In paragraph 9, 4 lines in, there was a higher overall figure agreed at the national
Yes, Mr. Chaffee.
Well, just before the break, I was going to take my lords to paragraph 311 of the Divisional Court's judgment, which is in the core bundle at page 254.
Thank you.
Paragraph 311 accurately summarises Mrs. Hoareau's essential complaint that, having carried out a needs assessment that includes a figure of 6.6 million for the Seychelles Chagos Islands, it was simply removed from the budget without ministers being informed or an explanation given. Ministers not given an accurate or fair presentation of the 40 million figure, not going to achieve what ministers were told it was going to achieve, and so seeks reconsideration of the figure of 40 million. And then the Divisional Court's response begins at paragraph 312. Nature of the remedy claim reveals a core fallacy in the position. Pursuant to the support package decision itself, the government is in any event actively considering the correct figure to meet the cost of an appropriate support package for all Chagosians, including those in the Seychelles. The figure of 40 million was always approximate, indicative only, never a finalised amount. So much is clear on the face of the documents, and so on. Now, that would be a sound, indeed, powerful point, if it was accepted on behalf of the Secretary of State that this error had in fact occurred, that there was a presentation to ministers or to the Prime Minister on an incorrect basis. But there has never been any such acceptance. So if what the Secretary of State said, yes, well, we didn't put it quite right to the Prime Minister, we've still got to come up with the exact figure as of now. As it happens, 3.5 years later, virtually none of this money has yet been dispersed. The reason for that seems to be that the Mauritian government don't wish to cooperate in assisting its expenditure, but never mind. But if the government was saying, well, yes, we will look at that figure of 40 million again in light of this mistake, and of course it may be that current budgetary considerations mean that it's impossible to increase it, in which case that would no doubt be not amenable to public law challenge. But to say that we're going to look at the final figure when we come to hand out the money isn't good enough unless the mistake is recognised as having been made. They have to at least consider it on a correct factual basis. But that's not, as the appellant understands it, the Secretary of State's position. Now, the Divisional Court goes on in its analysis, and a summary of it is at paragraph 318 on page 256. Divisional courts say that, in short, ministers did not have less information than the law required, nor were they materially misled. There's never been any suggestion that the Seychelles Chagosians were to be excluded as a result of the removal of the sum of 6.6 million. The fact that ministers were not told of the missing 6.6 million does not vitiate on grounds of irrationality the decision to commit in principle to a support package with an indicative value of approximately 40 million. The broad aim and cost of which were apparent and would include Chagosians and Seychelles, final details to be determined and which legitimately involved budgetary and so on consideration. The difficulty with that argument is that ministers were told that if you spend £40 million, you can, we think, achieve all of these things, particular healthcare and educational facilities for the Chagosians in both countries. But in fact, the understanding at the time was that you couldn't, and that would cost 46 million. And so that is the fundamental problem with the analysis and the presentation that was made to the Prime Minister. There's no suggestion that, in fact, Seychelles Chagosians will, when this money is eventually spent, be entirely excluded from the support package. Now, I'm sure the government isn't intending to do that, and we've never suggested they will. But the problem that we've identified is that the funding which has been allocated is not funding which is sufficient to achieve what the Prime Minister was told that amount ought to achieve. Now, had the Prime Minister been told the proper position, she may have reached one of two conclusions. One conclusion, she said, all right then, she may have said, all right then, I'm prepared to spend 46 million because this seems like a sensible package and that's what I'm told it's going to cost. That's one possible outcome. Another possible outcome is she may have said that's just too much money, given other budgetary requirements, and I'm not prepared to spend it, and the amount which I'm fixing on will be X. Now, both of those decisions would no doubt be perfectly lawful as a matter of public. But the problem is that the Prime Minister wasn't given the opportunity to take that decision on a correct factual basis. And so that's why we say that element of the support package decision requires reconsideration. And of course, it's a particular concern to the Seychelles Chagos, because the historical position, of course, has been that they have been essentially forgotten. The focus has been on the Mauritian Chagos, not least because of the ongoing sovereignty disputes and the particular interest and need for the support of the Seychelles Chagos, who of course live as effectively an underclass in the Seychelles, haven't been properly considered.
Now, Mr. Jaffe, I just want to understand what this, assuming you're right about these points, what it goes to. Does this go to, you said what you want is a reconsideration
Yes.
of that aspect, as though you're detaching it from the rest. I mean, this isn't part of an irrationality argument, then?
It is an irrationality argument. It's a fundamental error of fact that the budget was presented to the Prime Minister on an entirely incorrect factual basis, and therefore it ought to be reconsidered on a correct factual basis. Neither I nor the court can dictate what the outcome of any reconsideration ought to be, but nonetheless it does need to be reconsidered on a correct factual basis.
All right, but this is, as it were, totally detached from the other arguments that you've got.
Absolutely freestanding.
It's a freestanding point.
It's a freestanding, very traditional public law, domestic rationality challenge.
Yes, thank you.
Can I just virtually look behind me before finishing my submission? No, unless I could assist the court any further, those are the first.
Well, I have no further questions. I don't know whether Lord Justice Dingemans or Lord Justice Green have. No? No. Look,
I have further questions. Thank you.
No, thank you very much indeed, Mr. Jaffe.
My lords, I'm just trying to start my video. I hope it will start in a second. Yes, I think it has. So, can you all see me?
Not yet. We can hear you. We can't yet see you. According to what I can see, your video is not yet on.
Okay, it's telling me it's on, and I can see myself, but I am not quite sure what.
Have you pressed the play video bit of it?
Yeah, so you have a choice of video off or video on, and my video I have now switched on, supposedly, but it doesn't seem to be registering with you.
Well, anyway, the main thing is we can hear you.
I can see Miss Kaufman for what it's worth.
Ah, all right.
I have the misfortune of seeing Lord Justice Dingemans twice.
All right. Anyway, look, Miss Kaufman, you carry on, because the main thing is that we can hear you.
Yes, of course. So, as Mr. Jaffe has indicated, I'm going to take the second ground of challenge, which is based on the common law, based on administrative law principles, and which is in essence that the Divisional Court erred in failing to apply anxious scrutiny to the decision-making process in this case. And as we'll see, that is not just failing itself to apply anxious scrutiny in reviewing the decision-making process, but failing to look at that decision-making process as one which required the decision makers themselves, the MSC, themselves to apply anxious scrutiny. To make good that argument, I'm going to have to go through a number of steps, and if I might just start by outlining for you what those steps are going to be, so you have a clear understanding of the route I intend to take. Firstly, I'm going to look at the right of abode as a creature of the common law. So I'm going to seek to establish, or rather to show your lordships, that that right is already established and well recognised in our common law. The next question that I'm going to ask is whether or not the common law right of abode existed in Biot before the 2004 order was implemented. The next question I'm going to ask is whether the implementation of that order, which its common ground extinguished any right of abode that might have pre-existed its implementation, whether the consequence of that is that the right no longer has any bearing upon the decision making which is in issue in this case. And next I want to turn to the international plane, and I'll be able to take it relatively quickly because Mr. Jaffe has already taken you in detail to the ICJ opinion. But the question that we are asking in relation to that is, firstly, and this is in large part already answered, do the claimant Chagos Islands have a right to self-determination as a matter not just of international law, but as a matter of customary international law? And if they do have such a right, does that right impinge upon the decision-making process that was undertaken in 2016 and led to the decisions on resettlement and the fund? And if one or both of those rights, the common law right of abode, the customary international law right to self-determination, do impinge on the decision-making process, and how do they impinge? What does anxious scrutiny actually require? And once we've settled all those matters of law, as it were, and principle, I'm then going to turn to the decisions and seek to apply those principles to establish why the Divisional Court erred in failing to conclude that the National Security Council, the effective decision maker in this case, had erred in law in failing to consider, this is the first decision we're challenging as part of this process that went on in 2016, that the first error of law was a failure to consider whether or not to restore the right of abode irrespective of the decision not to resettle and not to fund resettlement. That's the first error of law we submit that this decision contains, or these decisions. And secondly, turning to the resettlement decision itself, how, given that the Divisional Court did not apply anxious scrutiny, did it fail to identify errors in the decision-making process? So to put that another way, had the Divisional Court applied anxious scrutiny to this decision-making process because it recognised, as it should have done, the fundamental rights were at stake, how would that have affected its review, and what errors ought it to have identified in the decision-making process undertaken by the NSC, and what difference would that have made had it approached its own review on a proper footing? So that's where I'm going to go. So can I start then with the question, is there a right of abode at common law? And the answer to this question is actually given in the Supreme Court's decision in Banco number 2. I'm going to have to just have a little bit of a look at some passages in the judgments of the court and some of the arguments that were actually put before the court in order to understand quite how the answer has already been given. So that is at tab 16 of the Core Authorities bundle. It starts at page 410. If I can take you first to the argument, and I only want to take your lordships to this one, so I'm going to deal with 2 points here insofar as this judgment touches on them. Firstly, the existence of the right of abode within the common law, and secondly, the separate question whether or not that right existed in the British Indian Overseas Territory before the 2004 order, because this judgment is decisive of both those issues. So if we can look first at the arguments put forward on behalf of the claimants by Sir Sidney Kentridge, if we start at page 423 at G, and he starts by looking at what the implications are of the fact that the Chagos Islands, the Chagos Archipelago, is a ceded territory, and what the implications are of the application of the common law, rather than focusing initially on what the rights are that the common law confers. So if your lordships can read G through to the bottom of that full paragraph as it ends at G on page 467. On page 467, internal page 467, he makes the argument that by it became a separate colony in 1965, the Order in Council provided for the continuation of laws in force at its date in any of the islands comprising the territory, including section 12 of the Constitution of Mauritius. And if we can then follow down the page to G.
Sorry, because you're switching, I think, between internal pages and file pages.
I'm so sorry. So
it's all right, no problem.
External page 424.
Yes.
Is it easier if I just keep with the external page?
Well, I think so far we've just been using the file page.
I'll do that.
Pages, yes.
I'll do that. So we're on page 424. We've finished the passage at the top of the page, A and B, that paragraph.
Yes.
And then if you move down into the next paragraph, between C and D, about 4 lines up from the bottom, there is a sentence that starts halfway along the line, when by it became a separate colony in 1965. The Order in Council provided for the continuation of laws in force as at its date in any of the islands comprising the territory, including section 12 of the Constitution of Mauritius. And then at G, on the same page, we turn to common law rights. And he identifies certain common law rights are recognised as fundamental despite the vagueness and uncertainty referred to in Lionage. A citizen's right of abode in and return to the territory of his citizenship is such a right. As a citizen of the United Kingdom and colonies, by reason of his birth, in and connection with Biot, the claimant had retained his right of abode there, including the right not to be excluded or exiled from Biot. This is a fundamental right of citizenship. The right of entry and abode in relation to any part of Her Majesty's dominion is part of the common law of England and does not exist only by virtue of express enactment. The right is an ancient one. The Crown never had a prerogative power to prevent its subjects from entering the kingdom or to expel them from it. And although in relation to specific territories within the Empire or Commonwealth laws might be passed which controlled the entry of British subjects from other British territories, there is no example of any law prohibiting a British subject or citizen who belonged to a particular territory from entering or remaining in it, except in the case of the Antarctic, which is uninhabited. And there we can see Thornton and the police being cited as not being on point. The fact, and we'll see, and it is a case relied upon by the Secretary of State, but that relates to British United Kingdom citizens and their rights to enter overseas territories, not the United Kingdom. The fact that the islanders did not own real estate on the islands cannot affect the position in public and constitutional law. If we then, so those are the arguments that were put before the court. If we then move on to Lord Hoffman's judgment, which starts at paragraph 42 on page 441.
Yes.
And he sets out here the extreme nature of Sir Sidney's arguments, which was that the Crown has no power to remove an islander's right of abode in the territory at all by exercise of the prerogative. And he felt that this was too extreme an argument. But if your lordships go on to read paragraphs 42 through to 45, you'll see that he doesn't dissent from the argument that as a matter of common law, there is a right of abode. So the point he makes in paragraph 45 is that the right of abode is a creature of the law. So the law gives and the law may take it away. And he then cites the case of Sims and O'Brien, the House of Lords case, which was addressing the circumstances in which a piece of legislation will be construed by the courts to take away fundamental rights or interfere with them. And that case establishes that where the statute expressly removes the right, then the court will give effect to that express removal. The law giveth and the law taketh away. But where the issue of the removal of the right is one that arises by implication, then the courts will construe that legislation narrowly and only conclude that the right has been taken away where that is a matter of necessary implication. It necessarily follows from the scheme of the Act and the language of the Act. So in relation to Biot and the Constitution Order of 2004, Lord Hoffman's position is, yes, there was a common law right of abode, but by the express terms of the 2004 order, that right was taken away. And that is as far as the right goes in the Biot. Lord Bingham, at paragraph 70, was also clear that as a matter of common law, there is a right of abode. If your lordships can read all of paragraph 70 on page 448 and the first part between A and B on 449.
Yes.
And the passage at the top of page 449 is particularly important because it identifies the principle, the reason why a right of abode is both a constitutional right and a fundamental right, because it's impossible to conceive of a state without at the same time requiring that there be a right of abode in the people who the state represents, because it is a reciprocal relationship. The state only exists to represent the interests of its people, to act for the benefit of its peoples, and it does so within a territory which is defined by the abode of its peoples. So there is an essential interrelationship between the state and its peoples, and sitting at the very, very foundation of that relationship is that people whom the state represents exist within a territory that is theirs, and the state sits on top of that territory representing their interests. So it's understandable why Sir Sidney sought to argue that you cannot possibly remove the right of abode by way of the prerogative, because it is such an integral part of the very notion of the modern constitutional nation state. If we can then move from Lord Bingham...
Are you suggesting there's a difference between Lord Hoffman, who says it doesn't help to call it a constitutional right, it's an important right, and Lord Bingham, because you seem to be suggesting Lord Bingham was saying it is a constitutional right? Is this an important distinction? If so, what do the other members of the appellate committee say about it?
Well, if we'll come on to it. The other members of the appellate committee, save for Lord Roger, were pretty clear about the very, very fundamental status of this right. And so we can see in relation to Lord... if we move on in order, we look first at Lord Roger, who really just assumed the existence of the right. He addresses this at paragraph 110.
Right.
And then if you turn to Lord Carswell at paragraph 123 to 124. Makes it quite clear he sees this right as fundamental. So 123 is on page 465. The desire to be able to remain in one's homeland is so deeply ingrained in the human psyche that the right not to be exiled could readily be regarded as fundamental. Given its high importance, the issue is how near it is to being an inalienable constitutional right. And that was the argument being put by Sir Sidney, that this is actually an inalienable constitutional right, rather than a right which can be abrogated more readily. So there are two aspects there to the nature of this right which give it its fundamental character. The one is the one which Bingham refers to, which is that it is an absolutely foundational right for the very notion of a modern constitutional state, which derives its legitimacy from the people that it represents. And here there is much more of a psychological element to what makes this right fundamental. It is something that we as human beings feel an exceptionally deep attachment to at a psychological level, but both reasons apply to give it its fundamental status. And then at 124 he looks at how long the right has been embedded in the common law. If your lordships just read that passage. And the next passage I'd ask your lordships to turn to is paragraph 151 in the judgment of Lord Dingemans. It starts at 476 at the bottom. If I can ask your lordships to read 151 and then I'm going to take you on to a number of other passages quickly, and then there's another passage I'm going to ask you to read on your own.
Yes.
So if you can go from there, and I'm moving now to 153 at the top of page 478, I'm sorry. Mr. Crowe submits that the common law principles governing persons with a right of vote in England have no relevance to ceded territories like Biot. So, assuming the right exists as a matter of English common law, it doesn't apply in Biot, argued the respondent, because this is a ceded territory. And at 154, Lord Mann says this: as to Mr. Crowe's former submission, the common law position must, in my opinion, be that every British citizen has a right to enter and remain in the constitutional unit to which his or her citizenship relates. That is the case in the United Kingdom. And then he moves on at 155 to address the arguments that have been put as to why this right does not exist in Biot. And if your lordships will read 155. So there is a fundamental distinction drawn where territories are ceded between the application of private law, which remains the law of the country that has been conquered, and public law. And under public law, once the Crown becomes sovereign, then that relationship of reciprocity is necessarily established. The Crown represents the interests of the people. The Crown is effectively an emanation of the people. And that right of abode that is part of our common law and a fundamental underpinning of that constitutional relationship travels with the Crown into the ceded territory. So the position following Banku number 2, is in our submission quite clear that a right of abode is a matter of the common law. It's a right conferred on the common law. It is in and of its nature a fundamental constitutional right. That doesn't give it any magic, but it is important in terms of the gravity of any interference with it. And the right subsisted after the creation of Biot, and the right subsisted before that when the Chagos Archipelago and Mauritius were ceded to the United Kingdom. So, if we look at the position before the 2004 order, there was nothing inconsistent before 2004 with the continued existence of that right. So whatever was the position, for example, before 2000, when the 2000 order was passed, as Mr. Jaffe has shown us earlier on, the very terms of sections 4, 3 and 4 of the 2000 order restored the right of abode and the right to resettle on the part of the Chagosians, save for in respect of the British Indian, Diego Garcia. So it might be worth just looking back at that very briefly. It's tab 3 in the core authorities bundle. And rule 4, 3 and 4 are the provisions whereby belongers, as it were, had their right of abode restored to them. So there is no inconsistency there between the common law and the statutory regime governing buyout. And it also is relevant, though not necessary, that at that point in time, and since 1983, and this is the previous authority in the core bundle, the British Indian Ocean Territory Ordinance, number 3 of 1983, which again your lordships have seen, provides at paragraph 3, page 8, that the law of England shall apply insofar as it is applicable and suitable to local conditions, and shall be construed with such modifications, adaptations, and so forth. So before the 2004 order, there was nothing in statutory regulatory framework governing buyout that was incompatible with the right of abode. So the question then is, well, what is the impact of the 2004 order, which, as I say, we accept readily that the 2004 order, in its terms, on its face, clearly extinguished the right of abode that had pre-existed. The Divisional Court's decision and judgment was that the extinction of that right by the 2004 order had the consequence that the right has no further bearing, no relevance to, let alone provide some kind of constraint on the decision-making process undertaken in 2016. And in our submission, that is a fundamental error on the part of the Divisional Court. And that right which had existed, which had been extinguished, continued to bear upon the decision-making process in a way that is legally relevant. To make good that point, I'm going to take us all the way back to really the first case that dealt with anxious scrutiny, when it needs to be applied, and what constitutes anxious scrutiny. And that is the case of Bud Dayke, which is at tab 9 of the core volume of authorities. And it's an immigration case, and very, very many of the cases where the term anxious scrutiny is deployed by the court and applied by the court concern immigration cases, because they're cases where rights are involved, at stake, but not necessarily directly in play as they would be under the Human Rights Act, for example.
Sorry, Ms. Kaufman, do you mind giving me the page number?
Yes, I'm so sorry. So if you would turn to the internal page 104.
Can I ask you, Ms. Kaufman, this? I understand where you've come from. Right of abode at common law, important constitutional fundamental right. You can choose your descriptions, you put it in various ways. You accept, as indeed is inevitable from Bancourt 2, that the 2004 order took it away. You say it continued to play an important part of the decision-making process, but are we talking now, is that analysis, that last part, dependent upon the fact that you say that the taking of it away was effected, but effected in a wrongful manner, or that it was wrongful to have done it? You're not suggesting it was unlawful.
No. So Bancourt number 2 makes quite clear it was lawful.
It was
to
lawful, yes.
pass the 2004 order. So we do not seek to go behind the judgment of the Supreme Court in Bancourt number 2. But what we do submit is the fact that the right was extinguished does not mean the right has no bearing on future decision making in respect of buyout.
No, I understand that, but this analysis doesn't depend upon the wrongful nature of the way the Chagosians were treated in 2004?
In 2004, not at all, no.
And so, although you rest this upon the right of abode, we're really talking about a right of return, aren't we?
We are, well, one way in which to exercise the right of abode would be to be able to return, but we are talking about the right of abode because if one thinks about the resettlement decision going the other way and a decision being taken to allow and fund resettlement, which made it practically possible, then the right of abode would have practical life again. So the decision whether or not to resettle has a fundamental bearing upon the exercise of the right of abode, the future exercise, the possibility of exercising, the possibility of reviving the right. So what we're talking about here is the impact that these decisions have upon the possibility that the right be revived. And therefore, because of that possibility, because of the impact they have upon that right, the right falls to be taken into account in the decision-making process. And anxious scrutiny falls to be required, to be given to that decision-making process because the right, in that sense, is engaged. So we're not talking about a situation in which the decision positively interferes with the right because it's extinguished. But we are talking about a situation which is highly relevant to the future enjoyment of the right. Let me give you an example of this in a totally different context. So in the context of a life sentence prisoner whose right to liberty has been entirely lawfully taken away from him, he's been sentenced to 25 years, of which 15 are going to be spent in order to be punished. He's an indeterminate sentence prisoner. He's been sentenced to 25 years, of which he must serve 12 and a half years on punitive ground. So he's a mandatory life sentence prisoner, and his tariff is effectively 12 and a half years. After that, he will remain imprisoned for as long as he is no longer, as he represents a danger to the public. So his imprisonment is unquestionably lawful. His liberty is unquestionably rightly taken away. He has no exercisable right to liberty. He is held in Category A conditions, and if you're held in Category A conditions, you are deemed, by virtue of being so categorised, to be highly dangerous. So as long as you're held in those conditions, you haven't got a hope of restoring your liberty. Our courts have always looked at decisions about whether somebody should be held in Category A conditions as ones which bear upon the right to liberty. Not because they are decisive of whether or not that right to liberty will be enjoyed, far from it, they will not be. That prisoner, if he stays in Category A conditions or doesn't, whether the decision is lawful or not, will still be lawfully imprisoned. But it bears upon the liberty of the subject and the individual's right to liberty because it has implications for their ever being able to regain their liberty. Now, in the same way here, this decision-making process, whether to resettle, we say whether or not to restore the right of abode, which should have been part of the decision-making process, irrespective of resettlement, bear upon the enjoyment of the right to liberty and also, as we'll come to, the right to self-determination. And therefore, anxious scrutiny was required. But anxious scrutiny and the whole principles upon which its application is based is not founded upon there being a decision which in the here and now interferes with that right. It is a much more substantive principle that looks to do right given the gravity of the issues at stake. And here, what is at stake, potentially, is an issue of the utmost gravity, and that is the restoration of the right. So that's how we put it.
Thank you.
So if we come back then to page 104, and between F and G in the speech of Lord Bridge, as I said, this is a immigration decision where what is said is that the individual's right to life is at stake should the immigration decision be taken against him.
Sorry, which paragraph again? Which page?
It is page 104,
Thank you.
and it starts just below E. I approach the question raised by the challenge of the Secretary of State's decision.
Yes, thank you.
And that captures the beginnings of what is meant by anxious scrutiny. I think the court must be entitled to subject an administrative decision to the more rigorous examination to ensure that it is in no way flawed according to the gravity of the issue which the decision determines. And you look at the gravity of the issue as a matter of substance, not as a matter of form. This is a decision which unquestionably, or a set of decisions which unquestionably impinge upon the future enjoyment of the right of abode. And they are decisions that are thereby grave and important decisions, irrespective of the fact that the right of abode was lawfully taken away by the 2004 order. Because where we are now is 2016, circumstances are changed, and the executive is itself and of its own motion deciding to look again at the question of resettlement.
Can I ask a question?
Yes.
You're taking us to the well-known older cases on anxious scrutiny. In the last 10 years in particular, particularly when we're looking at proportionality, there's a long line of case law that everyone will be familiar with, which effectively says that the extent to which the court reviews a matter intensively is very fact and context specific. When you're dealing with an elemental or a fundamental right, the court will look more intensely at the facts. Is this anything different to that? I know most cases are in the context of proportionality, but it's a more general theme that when you're dealing with a basic right, the courts will roll their sleeves up to a greater degree. Everything's very, very context specific. Is this any different?
So the importance of anxious scrutiny, as we're going to see, is that anxious scrutiny doesn't just operate on the court. It's not just about how the court reviews the decision-making process. It operates on the decision-maker. And the decision-maker is required to apply anxious scrutiny. And that has implications for the decision itself and the process of the decision. And it also has implications for the court's review. What the court will look for in the decision-maker's decision-making is different. And it is the greater anxiety that is required in the decision-maker that the court has to be astute to look for.
That's again different in the case of proportionality. If the court's applying a rigorous review in a particular given case, doesn't that rather connote that the decision makers should do likewise?
So it is different from proportionality, and one has to. I'm not going to tread into proportionality because this remains an exercise in the field of irrationality, anxious scrutiny. It is not a case where the court is itself making an assessment of the merits of the decision as it would to some extent with a proportionality review. It remains for the court to review the rationality of the decision, but the court is required to review it with two critical distinguishing features that don't apply in conventional judicial review. First, the decision maker must apply anxious scrutiny. That means the decision maker really has to actually be able to show that he has taken into account all the key relevant considerations. It's not for the court to say, well, the decision looks rational in a Wednesbury sense. It's not a decision where the decision maker has taken leave of this sentence. There were many, many different considerations that played in favour of the decision. The decision maker has to show that he has had proper regard to the key considerations. That's the first point. And then secondly, there is the court's function. The court has itself to hold the decision maker to account in a much more anxious way. So we're going to later look at two errors that we say are ones which involve errors of fact on the part of the the NSC, which we say, if you apply anxious scrutiny, they result in a sufficiently flawed decision for this court to say that the decision cannot stand. So that's the making the difference.
Right. Can I just probe? Can I just probe, if I may, for the moment, the first of those? I'm sure you're going to expand on it in due course. And the way you put it was the decision maker must exercise special scrutiny, and I think you said must take everything, I think material, you can say that, into account. Now, just trying to work this through on irrationality. I mean, there are 2 points here. One is there are irrational decisions because no reasonable person in the same position could possibly have come to the same decision. There are other cases we're concerned with where a material factor has not been taken into account. Now, it sounds as though it's the second of those that you're really looking at.
Yes, so we are not, this is not a Wednesbury challenge where we are saying this decision is substantively bonkers.
No.
That is not our case. Our case is that anxious scrutiny is it is a procedural constraint on the decision maker in the court. So the decision maker must himself apply anxious scrutiny. He must take account of the right that is engaged, and he must show that having done so, he is weighing up those factors which favour the protection of the right, the restoration of the right, not interfering with the right if it's an interference case, as against those factors which don't. He must properly show how he is engaged with the significance of the decision in hand, in so far as it bears upon the right. And that has implications. So it's not just simply a case in which, on conventional grounds, one can show that there is an error of fact in a material way. It is more than that. It is more is required of the decision maker by way of process. And I'll make this good when we come to look at the nature of the decision itself and the ways in which features of the decision which favoured resettlement.
All right, but can I again? I know you're going to come to it. I just want to set the future for myself. So it's not a Wednesbury challenge. It's not sufficient, you say, for the decision maker to take matters into account. It's more than that. They can take everything into account. It's to do with the way in which they balance the considerations, taking into account the importance of the right in issue. Is that a way of expressing it?
It's the demonstration. The court has to be satisfied by a demonstration that they have given anxious scrutiny to this decision. They have themselves taken into account the right, its impact upon the decision, the factors favouring its exercise as against those factors which tell against. They have to show anxious scrutiny in the context of that right in question. And that is different to simply taking relevant considerations into account and not taking irrelevant ones in. It is about demonstrating that in the decision-making process. It is about holding the decision-maker to account by way of the process in which they reach the decision, to satisfy the court that they have given anxious scrutiny to the right. So it is very much not about looking at the substantive decision, looking at the outcome and evaluating the merits. It is about the process by which that decision is reached. And that is the focus of the anxious scrutiny.
Is that a convenient...
So that if the decision maker cannot show that they have had regard in their reasoning in relation to the decision to matters that have a bearing on that decision, then that is in and of itself a basis for that decision to be quashed.
Is that a convenient point to stop?
Absolutely, yes.
Very good. Are you on course in terms of time?
Yes, I think I absolutely should be. I hope so.
Very good. Well, thank you very much indeed. Well, then we'll start again tomorrow morning at 10:30. Thank you.
Did you get to see me or not? Did my video come back
Well,
up?
I didn't have that pleasure, but I think that Lord Justice Green did see.
not at all. As I say, I saw Lord Justice Dingemans twice.
Oh, well, maybe it's Lord Justice Dingemans who saw you, but I'm afraid I didn't have that pleasure. But hopefully tomorrow we will have that pleasure.
I'll see if I can sort it.
I in fact saw Miss Kaufman on and off, but sometimes the video appeared to be on and sometimes it appeared to be off, but it must be the connection.
Yes. All right. Thank you very much. Good night.